Do we have too much government?
We need to put people ahead of corporate profits.
This system is so lopsided.
This threat is a real threat to democracy.
And I think that's really important. That's something we haven't been doing in this country for a long time.
Where do you start? What do you do? How do you do it?
Access to Democracy and other Eagan community television programming is supported by Thomson Reuters, makers of Westlaw Next and based in Eagan. Through Westlaw Next and other innovative online services, Thomson Reuters is the world's leading source of intelligent information for businesses and professionals. Online at thomsonreuters.com. And by U.S. Federal Credit Union, the member-owned financial institution offering service, value, and experience you can trust to the greater Twin Cities community.
Welcome. Access to Democracy returns, and we're happy to have a return guest, the Honorable David Stras, Associate Justice of the Minnesota Supreme Court. And I think this is your third interview here, and what we're trying to do is break the record of Judge Paul Anderson, who's been here about 36 times, so we're well on our way.
So I only have about 15 more appearances to go then.
Well, about that. And welcome back.
Thank you, Alan. Happy to be here.
You first came here as the new boy on the block. You are now practically one of the senior justices in a period of 4 years. Tell us about the transition and what's happened.
Well, it's been interesting. I mean, there's been a massive amount of turnover on the court just over the past few years, with Justice Paul Anderson leaving, Justice Helen Meyer, and Minnesota has a mandatory retirement age of age 70, and so there's going to be a couple more of my colleagues who are likely to go in the next few years as well. Certainly the experience helps, but it's also challenging. At the U.S. Supreme Court level, one justice, I think it was Justice Ginsburg, was quoted as saying, every time there's a new member of the court, it's a new court. And there's a lot of truth to that. It takes time to adjust to your new colleagues, and so while it's interesting and it's fun to hear what somebody new has to say, it's also challenging because
it can also change the balance of power.
Absolutely,
certainly in the U.S. Supreme Court, which has been 5-4 and so much, and even your court has been 4-3 quite a bit.
That's absolutely right, and so you never know where those 4-3 decisions are going to come out with new members of the court, and I don't think the governor really knows what the viewpoints of who they're going to appoint and what they're going to hold in particular cases. So it always presents an interesting dynamic for everybody involved.
Well, you came from Kansas. This sure ain't Kansas anymore, and you taught as a professor at the U. You now are firmly established with the Supreme Court here, and you also clerked, and I have to thank you in advance because you arranged a tour through the U.S. Supreme Court for me on a novel that I was working on and have completed recently through Justice Clarence Thomas's chambers, and that's who you clerked for. And talking of Justice Thomas, what I read and what I think I recall you saying is that his demeanor off the bench is entirely different than what is basically his silence on the bench. He has rarely asks a question. So what's he like as an individual?
He is truly not what you would expect. He's vivacious, he's outgoing, he's friendly. When I clerked at the court, he literally knew the name of everybody who worked in the building, their families. He was always asking people questions, interested in people. He loves being around students. So a few years ago, I had the opportunity to co-teach a class with him at the University of Minnesota Law School, and he went out of his way to meet individually with the students. He is just a gregarious, fun guy to be around. Great personality, great sense of humor, and you don't get that from his time on the bench because he doesn't talk much.
That's it. He's, the quiet man. I don't know how many years it's been since he's asked a question now.
Yeah,
but it's been quite a while.
Yeah, it's been a few years.
Yeah, and philosophically, where he sits and where my head is, is probably not in the same place, but you have to respect the fact that you get to know him, and you have this entirely different view of him.
You do.
In fact, I heard this week for the first time, I didn't know that the clerks have to, well, by tradition, I guess it is, take each justice to lunch once during the session. So you get a chance to talk to all of them and sort of get some input.
I do. Justice Thomas's lunch is actually one that all the law clerks look forward to because he's just so much fun. I mean, he'll spend most of the lunch telling jokes and talking about things that are a lot of fun. And the personalities of the justices really run the gamut. They go from the very quiet and understated, like Justice Ginsburg, who certainly is opinionated and very brilliant, but not necessarily the most outgoing, to Justice Thomas, who can almost carry a conversation with himself. I mean, he's a very, very talkative guy, which is opposite to his public persona.
And so that has to be a great experience. Now, translate that into the Minnesota Supreme Court. The attitude in that court and the attitude with the clerks to the Minnesota Supreme Court.
I think it's very similar. We're very collegial. We get along with one another. That's true at the United States Supreme Court as well. There's fewer of us. There's 7 of us instead of 9 of us. But I think it's a great experience. And one of the things I carried through with my time clerking, including with Justice Thomas, was how to treat the clerks with respect. They work very hard for me. I give them a lot of responsibility. But at the same time, I think they get a lot out of it. And so the relationship is very similar that I have with my clerks that Justice Thomas had with me. And we do something similar to the U.S. Supreme Court. Every justice, instead of the clerks taking the justice out to lunch, every justice actually plans some event for the clerks. And so every year I have the clerks out to my house and we have a barbecue and we sit around and talk. And so we have a very similar tradition at the Minnesota Supreme Court.
But it's a great way also to break down barriers of differences, intellectual differences, and certainly philosophies. And that's got to be a very beneficial thing in the running of the court.
It is, and it really builds collegiality. And one of the things that's unique about our court, as opposed to maybe the U.S. Supreme Court, is you mentioned the 4-3 decisions, but I think that ideology and politics, the cases we have tend to not fall along what you would think of as political lines quite as much as the U.S. Supreme Court cases sometimes do. And so maybe that, because we're not dealing with as many sort of hot-button cultural and political issues, I think that also helps build collegiality and break down the barriers between the clerks and the justices and among themselves.
Now, one of the things about the court, of course, is how a decision is arrived at. The lawyers go in, they argue the case. Your court is what is known as a hot court. Mm-hmm. The judges have already read the briefs. I don't know if it's a practice to even pre-brief or start your opinions, but so when the attorney steps in, you know exactly what the positions of the two sides are. Where does the case go from there?
Okay, so once we've gotten an oral argument, the case has been subject to all the justices, and some of the clerks have read it. We've usually received a bench memo from one of the clerks at the court. We've thought about the case. In my case,
bench memo being
a memorandum that's supposed to be impartial, to take a look at the issues, to take a look at the cases and facts that are cited in the briefs, and to tell us what they found when they went and read those cases, what they found in the record. So we've had a memo that sort of impartially looks at the case. And then what I do, which is sort of unique, is I actually use a dictaphone and I dictate some notes that I have or some questions I have about the case. Not the questions I'm going to ask during oral argument, but the questions that I want to answer as the case goes forward. After the oral argument, after we've had a chance to ask some questions, we sit down in the conference room and we hash out the case. Somebody presents sort of an initial report, whoever was first assigned the case, they present the report, and then we go around the table by seniority and give our opinion on the case. And then we try to forge some sort of compromise that the majority author can then go back and write.
And I think what people don't understand is that the great bulk of cases that the courts decide, even the U.S. Supreme Court, are unanimous decisions. The ones that we read about, the ones that we hear about most often, are the ones that are contentious.
That's absolutely right. And in fact, there's a statistic that was just released earlier this week that this is the first time since 1940, I believe it's 1940, where the U.S. Supreme Court has issued more than 65% of its opinions unanimously. And so I think that number, as I recall, at least traditionally, has been higher for our court than it has been for the U.S. Supreme Court. We usually are in the 65 to 70% range on a regular basis. So a lot of these cases are unanimous, and people don't really understand that or see that.
And yeah, and again, it's what gets into the paper.
Right.
That now, I know when Justice Magnuson, it was Judge Magnuson who was here, the Chief Judge, and Gildea, one of the troubling things was lack of enough money for the court system, particularly in the hiring of clerks and things like that. I know in the Supreme Court, a judge can have, what, 3 clerks or 3.5 clerks?
At the U.S. Supreme Court, it's actually 4.
4. Now take us back to Minnesota, which has been under some budgetary constraints.
Yeah, and we have 1 1/3 clerks. So we have 1 clerk that works exclusively for us, and then we share a clerk with 2 of our colleagues. And so we are extremely lightly staffed, even compared to other peer courts around the country. And I think a good portion of the reason for that is the budget constraints. I mean, the budget, the legislature has always taken a very close look at the budget, but particularly during the downturn in the economy, there was a lot of pressure placed on the judiciary to make cuts. And so we've made a lot of those cuts. And it's put pressure on our ability, I think, to get our work done in a timely fashion.
Now, I know you generally write your own decisions. Some judges have them drafted by their clerks, etc. But at the moment, do I understand that you have 1/3 of a clerk and that's it?
I have the shared clerk that's working with me, and so that's, I've not only am I drafting the first draft and filling in the citations and reading through the record, which are things that I normally delegate, at least in the first instance, to the clerks, but I'm also doing the editing of my own work. So I'm going through and writing the initial draft that a clerk will sometimes give me, but then I'm actually fixing it and tweaking it, and so the process is now taking about twice as long to write.
It's also got to be very burdensome,
Right.
because the calendar of the court is pretty heavy.
That's exactly right. And so I'm hoping that I'm going to get a new clerk around the 4th of August, and I'm hoping that I'm not too far behind by then. But it's a new experience. It takes me back to my days of clerking, let's put it that way.
Do you pick your clerk, or does the clerk come out of a general group of people?
We get about 220 applications for 10 spots, so it's very competitive. We then meet as a group and narrow it down to about 25 candidates. We then do a group interview, which is very intimidating, might I say, for the clerk candidates.
I would think so.
We put them at the end of the table, and I kind of feel badly for them. We don't wear our robes during the interview, but nonetheless, being grilled by 7 Supreme Court justices is intimidating. And then usually out of that group of 25, I'd say 90% of the clerks are selected. You are allowed to go outside the group that's selected by the court, and I have, at least on one occasion.
And you make your own choice.
You make your own choice as to your 1 clerk that works exclusively for you. For the 1/3 of a clerk, you have to negotiate and be diplomatic with colleagues and try to reach some sort of agreement as to who the shared clerk is going to be.
Philosophically, are you better off with a clerk who shares your judicial view, or are you better off with one who's on the other side, so to speak, and you can really bounce things off each other and argue them?
That's an excellent question. I have hired all across the spectrum, from very liberal to fairly conservative, and what I'm really looking for is somebody I can work with, who I can get along with, but somebody who's really smart and creative, has a passion for the law, really loves what he or she is doing, and so therefore the politics of the particular clerk really are pretty far down the list, and I'm really just looking for somebody who I think I can work with. Now, if somebody were so far apart from me philosophically that I think it'd be hard for them to write an opinion of mine, certainly I'll take that into account, but barring that, I'm willing to work with anybody who's just really intelligent and has a lot of motivation.
And that also has got to be an important consideration.
Yeah, absolutely.
Another thing is, as of this coming Monday, the Supreme Court will answer the two big remaining cases on their docket for this session, this term, and they will leave until the first Monday in October. That's not the situation in Minnesota, is it?
No, and the U.S. Supreme Court justices go all over the globe, literally, during the summer months. They teach in Europe. They take trips. That's really not the situation we have here in Minnesota. We certainly do take family vacations and things like that during the summer months, but we are in session, essentially, not hearing cases, but doing work 12 months of the year. So we'll be hearing petitions for review during the summer months, where people are asking us to take cases that they've had heard at the Court of Appeals. We'll be writing opinions. We'll be meeting on a regular basis to do administrative tasks that the court needs to do. So we're basically working for the people of Minnesota year-round.
Now, I know you can't discuss anything that might come before the court. You can discuss things that have recently been decided, and only 2 days ago, you wrote a majority opinion in a SLAPP case, S-L-A-P-P. Explain what a SLAPP case is, and this is a case that apparently is the fifth in a series of cases by these same parties.
Right. And so sometimes litigation, at least the idea behind the SLAPP statute, sometimes litigation can be purely for the purpose of harassing the other party into deterring them from doing things that they have a constitutional right to do. And so the anti-SLAPP statutes, and many states have them, but Minnesota has one as well, and those statutes basically allow a court to dismiss a SLAPP suit, which is one that's designed to deter people from exercising their constitutional rights to petition the government or to free speech. But it's designed to allow a district court to dismiss that case very early in the case's life, much earlier than otherwise would be the case.
Because in some instances, a very wealthy litigant could then really harass a less wealthy or poor litigant by really hitting them with case after case after case, and the SLAPP statute is designed to prevent that so that justice can be done.
Yeah, and it actually goes both ways. In writing that opinion, we certainly looked at other SLAPP suits that had been decided around Minnesota, particularly those that have produced published opinions. And sometimes we have litigants who are very wealthy that are trying to deter somebody from exercising their constitutional rights. So it actually goes both ways. But the key is in most of these cases, the suit itself is being used to harass the person who's speaking.
And so what you did there is dismiss the petitioner's case there?
What we did was we interpreted the statute. Minnesota has an anti-SLAPP statute, and what we did is we looked at the statute and we said, the lower courts, the Court of Appeals, had said all you need to do is present allegations in your complaint, in evaluating an anti-SLAPP motion. And we said no. You actually have to present evidence, because the statute talked about a burden of proof and a burden of persuasion and a burden of production, and you actually are required to show evidence that this is this type of harassing suit. And so we just looked at the plain language of the statute and applied the plain language of the statute, and we sent it back down to the district court for a determination of any other pending issues in the case.
Some cases, though, are very contentious. And you authored a majority decision recently in the Axelberg case. And that was a really interesting case where a woman claimed necessity for driving drunk, in effect, or driving under the influence. And it was a 4-3 decision. You wrote the majority decision. And she was being harassed by her husband. And actually, he was arrested for that, but she also jumped in the car and went someplace to get away from him and was followed, and she was hit with a DUI. What's the rationale behind that?
Well, this was actually, it wasn't my opinion. I did join the majority opinion.
I thought
no,
that was your
it was
opinion.
Chief Justice Gilday authored for the majority, but I joined it, didn't write separately. It involved a very sad situation. It was a situation in which you had an abusive husband, and the husband went after the wife, and they were in a remote location. and the wife was justifiably scared. And so both of them had been drinking. The wife jumped in the car and went, I think, a mile or a mile and a half to the nearest resort or hotel.
And he followed her.
And he followed her by foot and eventually reached her. But by then, a bystander had intervened. They had called the police.
He's
and
pounding on the
he's
windshield
pounding on the
and broke
windshield.
the windshield.
That's right.
So-
And the question is whether or not under the license revocation statutes, whether or not there's a defense of necessity. So the idea was, as the wife claimed, that look, it was necessary for me to save my own life to jump in this car. And again, that was a question, at least in my view, a question of statutory interpretation. The legislature had set out a really comprehensive scheme.
Statutes mean a lot to you, and you
Absolutely.
really are really a strict constructionist from what I have read about the wording in statutes to some very erudite decisions, I might say.
Yeah, I mean, it is important, and the reason why is it's what the legislature gives us. It's a matter of separation of powers. And so it's important to look at the statute and not add to the statute because, it's the legislature that promulgated the statute in the first place, and the legislature can fix it. And so the fact of the matter is, in the Axelberg case, there was no provision for a necessity defense, and the statute was pretty comprehensive as it was.
So if there is to be a fix, it's got to come down with the legislature.
Yes, and we have seen it. We had a recent decision, one that I wrote, State versus Nelson, dealing with the care and support statute, and that dealt with criminalizing the failure to provide child support. And the statute was unclear, and we said the statute was unclear. And in the last legislative session, the legislature came back and they fixed the statute. They made it. I haven't read the statute, but they at least made an attempt to make it clear.
Well, that's really the three arms of government doing what they're supposed to do.
Right.
Yeah. Now, yesterday, we had a very unique decision by the U.S. Supreme Court that said that Massachusetts law of 35 feet boundary from anti-abortion protesters was a violation of the First Amendment. And I think it was unanimous in that respect. I think Chief Justice Roberts wrote that decision, if I'm not mistaken. My wife Sharon said, but the Supreme Court itself has restrictions as to how close you can come to the building. What's the difference between the Supreme Court and people who are being threatened by anti-abortion protesters? And of course, voting. You can only get so close to a voting place. And how do you make a distinction there?
I got to be a little careful on that. We've actually had a few cases recently, including one I authored, that dealt with no contact zones. In the case that I authored, it was called Rue versus Bergstrom. It dealt with, I believe, a 50-foot or 100-foot buffer zone around particular people, so I have to be a little bit careful. But what I will say is this is an area that's really coming on its own. So when I clerked, we had a case involving abortion clinics and buffer zones. About 5 years after I clerked, the court had another case dealing with abortion clinics and buffer zones, and now you have yet another case about 5 years later. So I think what we're seeing is this is an area of interest. It's an area that's developing for the court. They're spending a lot of time talking about the First Amendment, and might I add, this is a court that is extremely interested in the First Amendment freedom of speech. They have issued a number of decisions almost across the board to a justice. They are very protective of free speech rights. And so while some folks may or may not have been surprised with yesterday's decision, it really fits well within some of the emerging trends we've seen coming from the Supreme Court over the last 5 to 6 years.
They also said this week, and again, a lot of people were surprised, cell phones cannot be searched without a warrant.
Yeah.
And I had an interview with former Justice Anderson and Rick King of Thomson Reuters, and I said, I think the reason that they said that is because they all carry cell phones now, and it really brings it home to when you're arrested, do the police have an automatic right? Only in exigent circumstances, I believe.
Right.
Other than that, they have to get a warrant, which is easy enough for the police to do in that kind of a case. But again, that's a Fourth Amendment case.
Right. And one of the things that case shows is they're really struggling with emerging technologies. We're seeing so much in terms of the internet, in terms of GPS. We had the Jones decision a couple of years ago, which dealt with placing a GPS device on a Jeep Cherokee and whether or not that constituted a search. We're seeing so much in terms of these emerging technologies. I don't know if the justices, I'm sure they currently carry a cell phone, but I know when I clerked, there are a few justices, probably Justice Souter most of all, who were not willing to necessarily submit themselves to emerging technologies. And so these are areas that the court is going to have to continuously deal with, and I think we're going to see a whole lot of cases over the next 5 or 10 years where the court's dealing with some of these technologies, and they are not easy questions because with respect to most, if not all of them, obviously the founders couldn't even have anticipated that they would be created and how they would function in today's society.
Well, one of the things that I find really incredible about you is that you have total recall of a case, and you can just snap the name of the decision and who wrote it, and that's got to be a wonderful asset for you to have, or a blessing that you have to be able to have such recall of the entire scope of what you've handled.
Yeah, although I will say that part of it was I was better at it when I first got on the court. I've now sat on nearly 500 cases, I think, if you look back over time. And while the important ones still stick in my mind, and all of them are important, but the ones where I really struggled with something in the case, those sort of stick out in my mind. There's some that it's too hard to remember when the catalog is 500. And then I try to keep track of all the U.S. Supreme Court decisions, too.
Of course. You want to be up on what's happening, and then
Yep.
you have the Eighth Circuit to worry
Exactly.
about also. And yeah, nobody said it was going to be easy.
No, but I do spend a lot of time. I mean, one of the reasons why I think I have the recall of a lot of these cases is, I really spend a lot of time thinking about them, some more than others. I spend a lot of time reading. I spend a lot of time just reflecting about them, and it's reflected in my approach to oral argument. But when you spend so much time really engaged with the issues in the case, it's much easier to recall them rather than just sort of signing off on them. And so I try to really engage with them.
In 20 seconds that we have left,
Yes.
and I want to thank you again for coming in, because it's always
Sure.
a pleasure. What is the most difficult type of case for you to decide?
It's probably the first-degree murder cases. They're very difficult, very fact-intensive, and the facts are very difficult to deal with. So I'd say that's, as a class, the hardest.
Justice David Stras, thanks again.
My pleasure. Thank you.
And we got off just on time.
Good.